not even funny. She knows. No.
All right, so it's 10 o'clock and you're all welcome to today's episode of The Lawyer's Diary. Interestingly, it's also the last episode for the year 2020 as we plan to restructure it in the coming year. We are lucky to have with us two experts in the areas of disputes resolution. The first person is Lawyer Dinah Asonaba Dapaah. Lawyer Dinah is a legal practitioner called to both the Ghana and the New York Bar. She's currently the Vice President of the Ghana ADR Hub. So we couldn't have had a better person to discuss this topic than Lawyer Dinah. She lectures at Dapaah. She does ADR, Corporate Law and Governance, Public International Law, and Human Rights. Dinah is also a World Bank certifier trainer in corporate governance and also into human rights and ADR. She's trained lawyers and judges in Ghana, Sierra Leone, and Liberia. And her areas of research include ADR, corporate law and governance, and also human rights as well. Dinah, it's a privilege to have you today on the Lawyer's Diary. We are extremely grateful for your time.
Thank you, and my pleasure to be.
Our next guest is Stephen Osei. Kissi. Stephen was here last week with us when we were doing employment contracts. Stephen is an industrial relations officer and currently heads the Greater Accra Regional Branch of the National Labour Commission. She's dealt extensively with resolving issues when it comes to Labour Commission, and he's also sat in a lot of arbitration panels for the Labour Commission. Stephen, you're also welcome to today's episode of The Lawyer's Diary.
Thank you, Senior.
And thank you for last week as well. I mean, your contribution was...
No problem. Today, my madam herself is here, so today,
Yes. It's going to be a learning process for all of us. And if today is the first time of joining... I also have my notepad as well. If today is the first time of joining the Lawyer's Diary, we've displayed our social media handles. On Instagram, we are Lawyer's Diary Global, and then on Facebook, it's Lawyer's Diary. On YouTube, we plead that if you can subscribe to the YouTube channel. So far, we've done over 15 legal topics from commercial, criminal, human rights, and so many discussions which will be worth education. So without further ado, we can start straight. So Dinah, when we say arbitration, to the layman, what is arbitration? You're muted.
Sorry about that. See, so arbitration is a process. It belongs to a group, and general name we call alternative dispute resolution. Now, alternative dispute resolution looks at resolving disputes other than through the court system. Now, ADR comprises of a lot of process, including negotiation, mediation, and arbitration. So arbitration is one of the ADR processes, and by extension, it means that resolving disputes, a type of dispute resolution mechanisms, which does not go through what the layman actually says to know that you go to court, there's a judge, and there are processes to be followed in the courtroom. So arbitration is one of those processes that enables disputants or litigants to resolve their disputes, but outside the court system. Now, arbitration is one of the ADR processes. It distinguishes itself from other types of ADR processes like mediation in the sense that arbitration is quite similar to litigation. The differences being that the person who sits to decide the matter during arbitration is someone we call an arbitrator. So what we have in the courtroom, you have a judge, but in arbitration, you have an arbitrator. Another good thing is that arbitration usually focuses on appointing that arbitrator who has the specific expertise involving the subject matter of the dispute. I believe as we go ahead with some of the questions, more of the characteristics of the arbitration will come up. But in short, to the layman, arbitration is a type of resolving your disputes. And you don't resolve the disputes through court. You resolve it through this process called arbitration by appointing someone, a third neutral party called an arbitrator, who listens to the dispute, listens to the evidence, carries out the listening in a judicial manner like a judge would do, and then delivers what we call an award. So what a judge will deliver in the courtroom is a judgment, and what an arbitrator will deliver at the end of the arbitration process is called the arbitral award. Thank you. Okay,
so you mentioned that arbitration is one of the various ADR processes. Can you summarize in terms of the differences between arbitration and mediation, or probably arbitration and conciliation or facilitation? How is arbitration different from the other modes of resolving disputes?
Right. So the first thing is that arbitration is almost like litigation. If you go to some jurisdictions like the UK, they normally call it ADR and arbitration. Some jurisdictions do not see arbitration as part of the ADR processes, but most jurisdictions, including Ghana, we see arbitration as an ADR process because it is resolving a dispute outside the court system. Now, let me take, for instance, arbitration and mediation. The differences between the two is that all ADR processes have third neutral parties except negotiation. Parties themselves negotiate, bargain, and resolve their dispute. But between an arbitration, for instance, the third neutral party who helps to resolve the dispute is the mediator in mediation. And the third neutral party who helps to resolve the dispute in arbitration is an arbitrator. Now, in mediation, the mediator, who is the third neutral party, does not behave like a judge. He's only a facilitator. He only helps assist or facilitate the process of negotiation. And that is why sometimes mediation is also referred to as assisted negotiation or facilitated negotiation, because the mediator facilitates the negotiation process between the two parties. And so he cannot declare one party liable or not, or declare one party wrong and the other party right. He only helps through some skills that you learn as a mediator, such as listening skills, communication skills, to help the parties to talk and come up with their own resolution. But when you come to arbitration, the arbitrator sits like a judge. He conducts what we call a judicial hearing, just like you know in the court system. There is a presentation of the case of the claimant. There is a presentation of the case of the respondent. There are cross-examination of both parties. The arbitrator bases his decision on the evidences that have been placed before him. So unlike the other ADR processes like mediation and negotiation, where the third neutral party, in the case of mediation, doesn't deliver a binding outcome, let me put it that way, an arbitrator delivers a binding award, which is enforceable like a judgment of the court.
Will I then be right to say that then the only difference between arbitration and probably litigation is that in terms of arbitration, there's an expertise or an expert that deals with the matter? Because from the description, it appears it's similar to what happens in court.
They are quite similar. Of course, the judges do have the expertise in the various subject matter, but the truth is that the arbitration helps to use the delay associated with court, considering that arbitrators are not only judges, they can be surveyors, they can be engineers, they can be architects, so that if it is in respect of a dispute around engineering matter, the arbitrator is able, because of the expertise he has in the particular subject area, to be able to deliver an award. Now, people would rather resort to arbitration because the two are similar, like I said, because you have the attention of one particular person, unlike the court system, where you probably have a judge sitting on about 20 cases a day, and human as they are, they get tired or there's a lot of delay and they would have to adjourn the matter. But with arbitration, realize that the focus, there is ample time and focus on the particular dispute, because you do not, first of all, you choose the arbitrator. The parties choose the arbitrator based on the expertise, based on the availability of the arbitrator, and they conduct the arbitrator not fixed like the court system at their own time. So they can determine that we're sitting every day, let's say for 3 hours. But if you go to the court system, you can't have your case. Hardly will you have your case being heard for even more than an hour, because there's a queue and people also have to be heard by the judges. So yes, you may be right in saying that, but the truth is that arbitration tends to cut most of the delays that are associated with the court. And there's also the added advantage, especially if it is a peculiar subject matter. There's the added advantage that you can choose somebody within that particular field to be the arbitrator in that dispute.
So in terms of I'm still on the advantages. Why arbitration? Aside the fact that you get to choose who you want to deal in your matter in terms of expertise, and then it being fast-tracked, are there any other reason why I should opt for arbitration instead of litigation?
Right. I'll make two additional ones. The other advantage, of course, delay also comes with its consequential cost. Because if you're running a case in court for over 6 years, the court cannot be compared to when you're resolving your disputes within 6 months or a year, as the case may be in arbitration. Of course, there's also the argument, if you go very well into arbitration, people say, but I go for arbitration and I'm paying about $20,000 to the arbitrator for a particular matter. Of course, if you can resolve a $10 million case, pay $20,000 US, $30,000 in 6 months, I guess you cannot quantify and compare it when you run 10 years and pay legal fees and TNT, as is the case, from Then the other thing I want to talk about now is in respect of enforcement of arbitral awards across a lot of countries now, particularly if you look at the Ghana ADR Act, you realize that the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards is part of the laws of Ghana. Now, what this treaty, it is a treaty. So for the laymen who are listening to us, so a treaty is an agreement that is signed onto by various countries. What it means is that if I even obtain an arbitral award in Ghana, for instance, I can enforce it in all the countries that have signed the New York Convention. And I need not prove it like any other contract. So that is an added advantage now, that the award, even though may be obtained in one particular state, could be enforced in a varying number of states.
Okay, so let's take arbitration in itself. At what point can I resort to arbitration? Is it that during my contractual term, the choice of resolving issue or my dispute resolution measure should be strictly stated as arbitration before I can resort to arbitration, or it doesn't really matter?
Right. So unlike the other ADR process like mediation and negotiation, parties must consent to arbitration generally, except with what we call statutory arbitration, like what we have in the new Banking Act, where if there's a dispute in relation to the application of the act, you have to go for statutory arbitration. That's a different type of arbitration. But generally, parties must consent to go to arbitration. Unlike mediation, where you go to court, and most of you here would realize that sometimes the judges will order that you go for ADR. And when they order for you to go for ADR, they're asking you to go for mediation. But with arbitration, you realize that if you look at Section 7, for instance, of the ADR, you need the consent of the parties to ask them to go for arbitration. So you are right when you say that it must start with the contract with the other party, whereby you agree. And that is what we call party autonomy. One of the characteristics of party autonomy, you agree to go to arbitration. You cannot be compelled to go to arbitration unless there is a statute where the statute compels parties to go for arbitration, then we refer to that as statutory arbitration.
Because I know of instances where the government or the law has forced people, especially labor-related issues, to go for compulsory arbitration and stuff. With that case, because it's statutory, that is how come you don't need a consent.
You don't need. So the consent, more or less, because you have entered into that field, for instance, if it is the banking that's going for the license to operate a bank, etc., you're impliedly also consenting to all the regulations that come with it. So that is why you have the statutory arbitration. So there's deemed to be consent at the onset when you decide to play in that field. Other than that, between you and I, who are not regulated whatsoever by any statute, we cannot be compelled to go for arbitration without our consent.
Can I, in the course of my consent, withdraw such consent when I enter into arbitration? Because it's a voluntary thing, if I enter into it and I realize that probably it's not going my side, am I permitted to withdraw at any point, either before judgment or before an award is given?
Unfortunately, not with arbitration. With arbitration, once you sign on to arbitration and you contract with the other party to go to arbitration, it is only the two of you who can also decide not to go for arbitration anymore. I mentioned that arbitration is very similar to litigation. It will not appear after all the due notices have been given to you. The arbitrator will proceed to deliver his award, just like you see on the writ when you are sued and you are told that if you do not appear, the court will go ahead and hear the matter. Same with arbitration. That is another difference between arbitration and mediation. Now, mediation is voluntary, such that before the settlement agreement is reached, a party can walk away at any time. But this is not the case with arbitration. With arbitration, once you consent, unless the two of you decide not to go for arbitration anymore, if you think you're not happy anymore with arbitration, the other party wants to go for arbitration, the arbitration will proceed without you. After all notices have been given to you and you still fail to appear before arbitration, the arbitral tribunal shall proceed to deliver its award against you or against you.
Wow. Okay, so then what happens if in the course of my trial or in the course of the trial, I realize that probably the arbitrator is putting up certain comments or certain actions which I think will likely to be in my disadvantage? What are the steps that I need to take? Is it that because the arbitrator is appointed, I should wait till the award is given and appeal upon the award, or I can, in the course of the trial, make some objections to his inclusion in the matter?
Right, you could make objections, but again, you mentioned something which I want to address before we move on in terms of an appeal. Arbitral awards, you cannot appeal against arbitral awards, but you can set it aside, what we call, you can challenge the award or set it aside. And I invite you who are listening to me, if you look at section 58 of Ghana's ADR Act, it lists the grounds for setting aside an arbitral award. One of the grounds is that you were not given a hearing or the arbitrator did not follow the procedures that you agreed upon. So until you're able to establish the listed grounds under section 58, I'm afraid you cannot challenge the arbitral award or the outcome of the arbitration.
So it means that once you subscribe or consent to arbitration, you are in effect accepting whatever happens in the hearing.
You take your arbitrator and the arbitration as you find them. Yes.
Okay. But I want to take you back a while then. How do we appoint the arbitrator? How is the appointment process done? Is it that each of them chooses one and then both of them will choose a third person? How many arbitrators are we to choose? Or it depends on how complex or small the matter is? Who pays the arbitrator? And even in terms of venue, how do we choose a venue? Are we going to London to do it? Are we doing it in Ghana? Or what? How do we do it?
The answer to this very long question is a thesis on its own. So I'll try to initiating the arbitration procedure. So first of all, as we've stated, arbitration must be by agreement. Now, an arbitration the agreement to go for arbitration must also be written by the laws of ADR Act of Ghana. An arbitration agreement must be written. Now, the written does not necessarily mean it should be contained in just the contract. Even through correspondences like email, if the intention is established that parties have agreed to resolve their disputes through arbitration, then they are bound by the agreement to go for arbitration. Now, there are two types of arbitration proceedings. There's what we call ad hoc arbitration, and there's what we call institutional arbitration. Now, with the ad hoc arbitration, parties themselves will choose the rules and the procedure that govern the arbitration. Usually the challenge with that is very difficult to foresee all procedural matters that may arise for you to deal with it at the point of contracting or agreement. And that is where people prefer the institutional arbitration, because for instance, if we say that all disputes shall be resolved through arbitration under the arbitration rules of, let's say, the Ghana ADR, where I'm vice president, that's why I'm using it as an example. What it means is that the Ghana arbitration rules will apply. Now, in the rules, there are provisions for instance, where the proceedings will be conducted, that is the venue of arbitration, the language, the number of arbitrators, etc. They will have a list of arbitrators from which you can choose from. What it means is that if you do not subscribe to an institutional arbitration, parties themselves at the point of contracting must agree on these details, or can decide, and most people with ad hoc arbitration would use what we call the uncitrall rules of arbitration. They don't have to list every detail, procedural details around it. So at the point you ask, how do you appoint an arbitrator? There's a bit of caveat I want to put out there. It is usually not advised.
When you say caveat, mean warning. Because of our listeners, I am quite concerned about the choice of words there.
So there's a bit of advice I want to give when you say that, how do you appoint an arbitrator? It is not advised, for instance, at the time of contracting to say that when we have a dispute, we shall go to arbitration and we'll appoint Ms. Diana Asonaba Dapaah as the arbitrator. The thing is, what happens if at the point of arbitration I'm dead? Knock wood, I'm dead. It means you have to go back and then now agree on who will be the arbitrator. Now, you should point out that realistically, when parties are in dispute, hardly are they able to see eye to eye to even determine who next then becomes the arbitrator, because Ms. Dapaah has passed on, for instance.
Okay.
And say we'll appoint, let's say, 3 people or 1 as arbitrator. And perhaps you want to list some minimum, but don't be too strict. In fact, I've done a training on what we call avoiding pathological clauses. So for instance, you don't want to put in your agreement that we'll go for an arbitrator who is fluent in French and English, who has studied English law, who knows how to federal rules of you have nobody that kind of description. So when it comes to appointment of arbitrator, that's the advice I would like to give. Namely, you want to leave it a bit general. Like, for instance, you can say we'll appoint 3. Each party will appoint 1, then the 2 arbitrators will appoint the 3rd one. But of course, normally when you use institutional rules, for instance, the provisions of the arbitral rules of that institution will make up for some of these procedural matters that arise. I don't know if I left something out of your...
and then I was also asking about the venue, like the venue for arbitration. How do we choose the venue? Is it that once the contract is performed in Ghana, automatically the venue for arbitration must be Ghana, or either parties can choose that I want it to be done in London, or say the United States?
Right. So again, there are 2 ways of going about it. You can decide to sit in India and apply the contract laws of Ghana. The parties can choose at the point of contracting where they want to hold the proceedings. Even now with COVID, now a lot of people are going virtual and actually holding online arbitration proceedings. So, but before COVID and then virtual arbitration proceedings became the norm, people could sit anywhere. Parties at the point of contracting can agree where they will the venue for arbitration. Or if they resort to the institutional rules, as I've stated, what it means is that where is the dispute as to where the arbitration will take place, the institutional rules will usually provide. For instance, in the Ghana ADR arbitration, where parties do not determine where the arbitration will take place, the place of hearing shall be Ghana. So that is our default provision. So it means that if you invoke and apply the arbitration rules of the Ghana ADR, the venue of the arbitration will be Ghana. So the advice there is that if you're also choosing institutional arbitration, you should know thoroughly the arbitration rules of that particular institution, because their default provisions will be applicable where the parties have not agreed on a particular issue.
Okay, so in an instance where we just mentioned that it shall be 3 arbitrators, but we fail to mention venue, what happens?
So usually, if the provision says that there shall be 3, the practice is that claimants or party A will choose 1 arbitrator, and party B will choose the second arbitrator. Then the 2 arbitrators that have been chosen will choose a 3rd arbitrator who is like the neutral and who will chair the arbitral tribunal.
But I believe if I choose an arbitrator, I'm expecting the arbitrator will toe my line because I'm the one paying the person. Is that always the case? Or once you are appointed, it takes you from any affiliation into a neutrality ground?
Presumptively, it may appear that you become then biased to the other party. But of course, there's also arbitration ethics or what we call even ADR ethics. And one of the ethical requirements of arbitrators is that they should be neutral. Of course, people have argued that once you are appointed, you can never be neutral. But I always say that your career as an arbitration is developed by yourself. If you are noted to be a biased arbitrator, very soon nobody appoints you as an arbitrator. So there are obligations for arbitrators, even though they may be party appointed. And of course, for the sake of your own career and building your own career, you want to display professionalism and neutrality to the best of your ability.
In terms of payment of arbitrators, if I'm the one paying, how is it done? Is it that I make a deposit of the fees so that it wouldn't affect your duties? Or as and when the matter goes, I issue the payment? The reason why I'm asking is that, let's assume I appoint Diana. I see that Diana is asking me certain questions, which presumably the award is going to be against me. I would choose to say, I don't have much money to continue again, so I'm not paying. What happens then?
Right. So normally, if you choose institutional arbitration, let's say you come to the Ghana ADR, for instance, or come to the ad hoc arbitration, there's what we call the administrative expenses that you pay to the hub, because the hub will be in charge of giving it to the other person. So you pay the administrative expenses. Then you also pay the fees, both parties, or the parties share, split, and pay the fee of the arbitrator. There's been instances where the arbitration fee has been agreed. Before arbitration starts, there's usually a conference where all these issues are discussed. Now, there's been instances where one party has failed to pay at the stipulated time that the institution or the arbitrator requires them to pay. Normally, what happens is that the other party will pay up to pay the full amount, and then it will be factored into the award. At the end of the award, let's say if it is damages to be paid, it will take into consideration the monies owed into, I'm using owed reservedly because the other party has failed to pay the arbitrator's fee, and it will be deducted or will be added onto the damages depending on how the award goes. So same for it's one of the issues that arbitrator determines at the onset of arbitration with the parties, the fees of the arbitrator. So if the other party fails to pay, then let's say if party A fails to pay, party B can pay all of them, and at the end of the award, it will be factored into in determining, the reconciliation.
Are the arbitrators made aware of the party that hasn't paid? I mean, as human as we are, coming back and then I've seen one party paying me the full amount. There's some kind of it may affect the work as an arbitrator. Has there ever been an instance like that, or is it possible as initial arbitrator?
I've already mentioned that if you're an arbitrator and your focus is so much on some of these, biases or, as it were, prejudices instead of being professional, you realize that very soon you are curtailing your own career as an arbitrator. It's important, yes. Your fees are very important, but it should not in any way affect your judgment or
affect the duty.
If that is how you are, very soon, the word will spread and nobody wants to choose Mr. Dapaah as the arbitrator again.
Mm-hmm. Okay, so now I'm taking you back to the agreement again. Now, if the parties have agreed the terms of the agreement that it's going to be by arbitration, and then immediately there's a dispute, I rush to court, can I be pulled back into arbitration, or what happens?
Definitely. If you look at Section 8 of the ADR Act, it says that where a party realizes that there's an arbitration agreement and the other party rushes to court, I'm putting it in very simple language. You who realize that there's an arbitration clause, you can go to court. There's a procedure we call you and stay proceedings. So you can go to court in very simple terms and tell the judge that, my lord, we have agreed that between the two of us, all disputes shall be resolved through arbitration. So this guy has no business coming to the court. And the law says that the judge is mandated to now pause or hold the proceedings and sack the two parties back to arbitration.
Okay. In such instance, are the parties required to report back to court on anything, or once you are sent to arbitration, then the rules of arbitration takes place from there?
Right. It's very difficult to answer yes and no. So once you go, then the rules of arbitration commences until an award is delivered. But let's not forget that in the course of arbitration, even the Act gives some powers to the court to support the arbitration proceedings, for instance. So in terms of injunction, etc., you can come back to court for it. So it doesn't necessarily cut off the court, as it were, from the arbitration proceedings. But of course, there's also the care not to the court to intrude so much into the arbitration proceedings once they have been sent back to arbitration. And then it runs all the way until an award is delivered. Of course, if an award is delivered and the losing party complies with the award, then there's no point coming back to court for anything. It's only when the other party fails to, then you register the award and then it is enforced in the same manner as you will enforce a judgment of the court.
You mentioned registration of award. What is that?
Okay, so I use registration, but I'm also being careful not to use too much if you look at the Act, I think section 52 talks about enforcement of arbitral award, is that you apply to the court. It's a procedure that most lawyers will be familiar with. So you apply, it's an application you make to the court for leave to enforce that foreign arbitral award. And then the court then, if it grants the application, adopts it as if it is its judgment, it delivered the judgment, then all the known processes of a judgment will be triggered to enforce the arbitral award.
Okay, let me move to Mr. Stephen and then let you relax for a while. I'll come up to you.
Sure.
Stephen, I know the Labour Commission does arbitration. How is it done? What are the steps that the Labour Commission usually take in terms of undertaking arbitration processes in your commission?
Okay, I think that my madam mentioned that there are two types of arbitration. There's the ad hoc, and then there's the institutional arbitration, where if you go by the institutional arbitration, then it means that parties are bound by the rules of arbitration as the institution provides. It's the same thing that happens at the commission. You realize that the Labour Act for which the commission uses in its adjudication allows that arbitration can be done in the event where mediation and facilitation is unsuccessful. Now, beyond the unsuccessful nature of mediation or facilitation, if you find yourself in a business that is considered as an essential service, then it means that when disputes arise in your enterprise, then automatically you are bound by the to submit yourself for compulsory arbitration. So yes, the commission does arbitration as well.
So
the process.
All right. Practically,
no, you go ahead.
I mean, practically, what are the steps that I need to take if I come to the Labour Commission and I want to do arbitration?
Okay. The first thing we would look at is if you have a pre-existing agreement that allows that in the event of a dispute, the dispute resolution medium is arbitration. If that is already provided for before approaching the commission, then we'll adopt that and send you through the process. If that is not the case, then it means that you have come before the commission facilitation and mediation has not been successful, and therefore we subject you to voluntary arbitration. Now, the process requires that there's a database of persons who are qualified as mediators and arbitrators. So the commission serves you the list. You pick, so party A will pick from the list, party B will do same, and then you submit to the commission. Now, when you submit your preferred choice of arbitrators, the commission will look at it. If there's a common name, then that person is appointed as your arbitrator. If you choose just a single person to be, if you go through sole arbitration. Now, if you prefer a panel of arbitrators, the process remains same. We will look at the selection you have made. If both parties agree on persons on both sides, then it means that that person is the one who is going to be appointed to take you through the arbitration process. In the event where both parties are not able to pick out a common person, then it means that the law gives the commission the power to appoint an arbitrator for the parties, so that that arbitrator upon appointment would convene a meeting, which the arbitration conference, and then the details of the process is ironed out. Venue, language, time, fees, all of those things are agreed at that conference, and then the arbitration process starts.
Okay. But in terms of your work at the Labour Commission, when the statute forces people to come on arbitration, how have they availed themselves? Have they always availed themselves to such negotiations? And what challenges do you face in such processes when the state forces people to come for arbitration?
Madam Diana explained earlier, because of because of the nature of the process, once you are directed that following a failure of facilitation mediation, the next step is that you go through arbitration. For a disputing party, you are seeking for solution. So you realize that for most of the time, we rarely have parties deciding not to consent to arbitrate. Every time there is that cooperation, the consent is established, because the parties by themselves are hoping that by going through arbitration, some finality will be brought to their dispute, and whoever wins, whoever loses, we move on from that point. So the challenge really isn't about consent. The challenge about consent is usually at the mediation level, but when it comes to arbitration, we rarely face that kind of challenge.
Okay, thank you very much. If you are listening or watching us, this program is The Lawyer's Diary, and we come your way every Friday and discuss various topics. Today's program is actually sponsored by Enos Travel. I have the CEO of Enos Travel with us. I'll give him like 5 minutes to talk to us about Enos Travel, and then we can move to the second segment of the show. Dennis, if you are here, you can take over for 5 minutes.
Hello, lawyer. Can you hear me?
Yes, hello? We can hear you. Please go ahead.
All right. Good evening to everyone. My name is Dennis, as lawyer said. Enos Travels is organizing a tour next year. Hello, lawyer. Can you please give me the authority to share my screen with you?
I made you a co-host, so you can go ahead.
All right, I can go. All right. All right, so we are organizing a tour together with a music artist called Amrado. And many of you follow the Yet in Some series on YouTube every Friday. You know who Amrado is. The tour is going to start on the 17th of February to the 24th of February, and it's in 2 parts. We leave Ghana on the 17th and we go to Kenya. In Kenya, we are going to do the Giraffe Center in Lagate. We are going to have the Nairobi City Tour. We'll have a dinner at the Kanagori restaurant, and then we also have the Nairobi City Tour as well. From there, we move to Dubai. And then in Dubai, we are going to sleep in a 4-star hotel, which is the Hilton Garden Inn. It's an international brand hotel. We'd go to the 124th floor of the tallest building in the world, which is the Burj Khalifa. We'd also have the experience of the desert safari. We do the Dubai City Tour. We'd have a Dole cruise, which also has a Tanura dance show on it. And then we would have a live performance from the music artist we are going with, which is Armando. Now, this tour includes a return flight from Ghana to Dubai and back. It includes the tour in Dubai, the tour in Kenya, a branded t-shirt of Armando, hotel and breakfast, and then also it's all together 7 nights and 8 days. For a single price, goes for $1,400, which is equivalent to around 8,000 Ghana cedis. And then for a couple price is $2,700, which is equivalent to 15,000 Ghana cedis. You can start paying in installment because the tour is in February, and then we know people get paid. Most people in Ghana get paid at the end of every month, so you can start paying in installment and join us. The tour, as I mentioned, starts from February 17th to February 24th. And then what interests us is that we are going to pay for the PCR test that everybody has to do before you can travel outside Ghana. So it's all part of the $1,400 or the $2,700. And I can't wait to meet you all on this experience. Thank you very much for the opportunity, Laura.
All right, so if anyone wants to go, what are the numbers that the person needs to call?
All right, so you can reach us on our social media platforms. On Instagram is eno.travels. On Facebook is Eno's Travels. And then on Twitter is Travels Eno. It's Travels Eno on Twitter. So you can join us. You can also call us. I'll put the number in the chat. You can call us on 0241 065458, or you can contact Lawyer anytime, any day, and then he'll link you up to me. So I'll forward all the contact details in this chat so that everybody can have access to all the contact details and also the social media platforms. Thank you very much.
All right, thank you, Dennis.
I want to chip this in as well, if I still have time.
Go ahead.
Well, apart from this tour that Eno's Travels is organizing, we are all into helping people with their traveling, any traveling issues that they have to any of the countries that they want to go. If they want to go to the United States, they want to go to Europe, they want to have an experience in Asia, we offer all those services. So anybody can join us. If the person wants to travel outside Ghana, we've got the person covered. Thank you very much.
All right, thank you, Dennis, for the detailed advertisement. You need to pay us more money because this.
Of course, of course. So, and then anybody on this page today, if the person wants to register, because of the Lawyer's Diaries, we give the person a 5% discount.
And because it's also Black Friday.
Because it's also Black Friday as well. because of Black Friday as well. All right, thank you very much.
All right, Dennis. Thank you too.
Bye.
So, Lawyer Dinah, we are coming back to you on the next phase of our discussion. In summary, what are the challenges that is associated with arbitration?
Right. So I have hinted about them. I've heard people actually debate, or as it were, being skeptical when we talk about it reduces cost. Because of course, normally when people hear about you paying thousands, 5 figures in dollars or the CD equivalent, as the case may be, of arbitration proceedings, people have tended to say that it can be expensive. So one of the challenges that I can readily talk about now in terms of the cost, where you can pay huge sums of money. But some have also done the economic sense. I would rather pay that amount and have my case resolved for business people within 6 months or a year, rather than go through 10 years and you think you're paying, let's say, 500 cedis trans TNT, but then if you calculate that for the next 10 years and the whole stresses that come with it, I mean, I leave you to do the math. I can't even quantify what it means to go to court, and the judge is, of course, and did not sit on that day. So I can think of one of the challenges being the cost involved.
The cost. Okay, so in terms of, it all boils down to the cost. I mean that if I am a litigant or I come to arbitration, I also take care of all the logistic thing of the arbitrator.
Yes, you take care of the administrative expenses, as I've mentioned. For most of these ad hoc institutional arbitration, you pay the institution and then you pay the arbitration test. The two are different. So yes, you bear the cost of the.
So it's just like litigation expenses and legal fees. Okay. So if anyone wants to come to arbitration at your place, the ADR hub, one, where are you located? And then the second thing is that if I come, can you take me to the process? What would I be required to do?
Right. I like to not so much emphasize on where we are located. As I've mentioned, we can be located. Currently, our main office is in Kumasi, but we run our services for arbitration, because parties determine where they want to sit. So as an institution, we only facilitate the process coming up with a list of arbitrators and other procedural issues. So even if parties decide to use the Ghana ADR arbitration rules, they are not compelled to come to Kumasi. They can decide we're sitting anywhere in the world. And that is the beauty of arbitration. We are having the hearing, so the arbitrator moves to the venue of the hearing. As I've mentioned, now, even with COVID, where most arbitration advocates are now encouraging the use of virtual hearings now. So the focus so much is not on where we are located as it is the services we render, because we can run arbitration hearings in Accra, beyond Ghana, etc. Now, if you want to use the Ghana ADR as your institution to conduct your arbitration proceedings, first of all, as I stated, it must be clear in your agreement with the other party. Where parties do not agree at the onset, I've told you that it's always healthier and easier when you are contracting to say that when we have a dispute, we'll go to arbitration, and using the Ghana ADR hub arbitration is easier. Because when the dispute arises and you have not selected the Ghana ADR hub, it's almost always difficult, or it may be impossible to choose. Parties will not even be seen eye to eye in the first place. So to play it safe, at the point of the agreement or the contract, you list that the dispute shall be resolved through arbitration under the Ghana Arbitration ADR Hub arbitration rules. So that's the first thing we look at, because without that agreement, we cannot also proceed to assist or facilitate the arbitration proceedings. So first of all, you must choose Ghana ADR Hub as your institution to run the arbitration proceeding. And
just
when
to
you
check on this, I know that most arbitration clauses just say that in an instance of dispute, it shall be resolved in accordance with the ADR of Ghana. Is that not enough to pull the person to the Ghana ADR hub?
No. So in that case, if you just say in accordance with the ADR rules of Ghana, the ADR Act of Ghana provides for an ADR center. Unfortunately, that center has still not been established. So then we are still left, there's a lacuna there. You are still left as to how you're going to run it. You almost then have to run it as an ad hoc arbitration, because the ADR center is not existent. So to use the Ghana ADR Hub or any other institution as the case may be, you must specify that institution. So it is not enough to say that we're using the ADR Hub groups to connote that you can come to the Ghana ADR Hub. And when that happens, usually just like one person starts litigation in court, there's always one person who will rush to the Ghana ADR Hub rules and tell us in simple terms that I have this dispute, I have this contract, we agreed to resolve all the disputes through arbitration. And the other party has breached the contract, and so I want to start the arbitration process. We file it with our administrator, and then once we receive the claim, we would then write to the other party, setting out the claim that has been brought, referring to the agreement to go to arbitration, etc., and inviting it to respond and come for arbitration. So from that point, the Ghana ADR, we become like the registrar of the courts, and then we now take over the arbitration proceedings. And if the other party responds, then the administrator will help them in choosing the arbitrator. If they did not decide who the arbitrator will be, normally we all use, just like Stephen mentioned, we use a list. We use the list. We normally have a list. Parties will go through the list and choose based on priority who they would like to be the arbitrator, where the common arbitrator that is chosen at the highest rank is then appointed as the arbitrator. Or if it is a 3-member panel arbitral tribunal, then as I stated, party A chooses one party P, then the 2 arbitrators will choose their 3rd arbitrator. The one the arbitral tribunal is set, then the parties meet the arbitral tribunal. When I talk of the arbitral tribunal, it can either be the sole arbitrator, that one arbitrator who was appointed, or the parties wanted 3 arbitrators. Discuss all preliminary issues, procedures, other things before the hearing itself starts. So then the hearing continues until the time that an award is given and then published to the parties. So in other words, if you want to come to ADR, you first of all must agree with the other party to come to ADR Hub. And then when there's a dispute, one party will then file the claim and the hub, and then the hub takes over, serves the other party, invites it to respond to it, and then the arbitration proceeding is carried on with the assistance of the hub.
Okay. We've spent almost an hour, 8 minutes to 1 hour already. It appears that people's awareness to arbitration is still very low. Any recommendation on how to make people opt for arbitration or opt for ADR instead of litigation? How do we go about it as a nation?
Right. So I guess I've had the privileged opportunity to speak at such forums, just like the Lawyer's Diary, where we've advocated for other means of resolving this. And I always use this illustration to explain why it is necessary for us as the public to actually engage in ADR or other forms of dispute resolution. The illustration is given like the hospital setting. You know, when you go to the hospital, there are general practitioners and there are specialists. Of course, if you have an ear problem, you go to the ENT specialist. If it is about children, you go to the pediatrician. If it's women-related issues, you go to the gynecologist. So there is not as if one cup fits all kinds of disputes, just like we have in the court system, or just like we have in disputes. It is not the case that litigation alone should fit all manner of diseases or illnesses or medical issues, just like we have in the hospital settings that people specialize in particular kind of medical issues. So that is the same awareness we need to have at the back of our mind, that litigation is not necessarily opposite. The best way of resolving dispute for all manner of business relations, family relations, other issues are the reason why we should explore and in fact choose alternative dispute resolution. And then you can also talk of some of the advantages it has, such as building relationships, reducing cost and delay. But if we would all explore other forms of dispute resolution, believe you me, the courts will be decongested. But currently we are all trooping in, and the reason why we're all complaining about the pressure in the courts and the delays. Meanwhile, there are other modes which are more appropriate for these people. So if we go deep into it, there are other forms. We have what we call rent a judge, mutual fact finder, etc. You know, so we should not be dogmatic in saying that litigation is the only way for resolving dispute. But just like the hospital system, know that some types of challenges or ailments are better resolved by some type of specialist or experts.
Wow. Thank you very much. Thank you very much, Wadana. Thank you very much, Stephen, for your time. We have just 5 minutes remaining. I'll ask our viewers and audience to ask any question that you may have from the discussion. Or I've received so many questions, but you answered most of them during your lecture. Most of them were, who pays for the arbitration award? How do I choose the venue? What are the challenges with arbitration? In terms of award, how do I enforce the award? So all the questions that came before the program started has been vividly explained during the lecture. So Frederick, you can go ahead with your question. Hello? All right, we have 4 more minutes before we wrap up. So Father Dusi, if you have any contribution or things, you can go ahead with it. Your microphone is muted, Father.
Is it still muted?
No,
hello?
It's fine.
Oh, okay. So first of all, thank you. As always, thank you very much. We are priests and we need you to fill in those other areas where we are very ignorant. So thank you so much. I just want to say that as a priest, every time I read, for example, Matthew 18, 15 to 17, no, Jesus is saying, if you have a problem with your brother, some fault, go to him personally, just the two of you. If it doesn't work out, call 2 people. And if it doesn't work out, then bring it to the church. And if that also doesn't work out, you've done all you can. And the other thing I want to say is that Jesus is saying, you choose 2 and go then to the person. Now from this talk, it looks like even though it would be ideal for you to choose 2, there's the need for the 2 parties also to know who can be the arbitrators. So it's just taking it from a funny side and saying, thank you. Can you tell me as a priest how to bring the 2 together? The 2 agreeing on who the arbitrator should be, and this test from Jesus who said, you choose 2 people to go and go to the person.
Right.
I'm just taking it from the funny side.
Yeah. No, that's a very interesting, but you also raise a very good point I wish to bring up. In arbitration, the arbitrator must always be an odd number, unfortunately. So much as I want to follow Christ's stone, we can have 2 arbitrators. The reason is that the sword must fall one way or the other. You know, there has to be with 2. If one says, oh, party A is liable, and the other says party B is liable, then where do we go? So it's like the system in arbitration, there must always be an odd number. So usually is 1 or 3, you know, so that either way there will be a majority. It's either unanimous or that is a majority. But you're right, in mediation, you can actually have 2 mediators. Because like I stated at the beginning, the mediators do not take a decision for the parties. They don't rule. They don't make judgments. They only facilitate the process through, as it were, bargaining the parties. So in mediation, you can actually have 2, because it's the parties that decide how they want to resolve it. So it's, I mean, much as you're trying to give us the funny aspects of, you brought up a very important point that in arbitration, the number of arbitration will always be an odd number. So thank you
so much. Thank you so much.
I think that Jesus was more of a mediator than an arbitrator.
Jesus was more of
a mediator
than an arbitrator.
That's right.
All right, so if any other person wants to make a contribution, the person can go ahead before we draw down the curtain.
Well, mine is not a contribution or a question, but then I would like to thank Diana and Stephen for giving us such much insight into arbitration, mediation, and all the labor stuff. And then thank you very much, Father. You always come in with the religious side. So thank you very much. And I look forward to meeting you all.
Nice seeing you.
In Dubai.
Okay. Yeah, we will work at it.
So Dennis came again to do advertisement. So you have to also.
Well, we will work at it. We will work at it.
If we are doing advertisement, I mean, you can check. I don't know if you can see my view. I'm currently in Florida.
Wow.
And yes, you could check all the actually the higher, yeah. So you could check all the boats and then the ships passing by, and then these are all the places that Enos Travels can bring you whenever you want at a very less expensive, not cheap. Cheap is not good, but then at a very less expensive cost. So I look forward to seeing you all in Dubai.
Thank you. Thank you very much. Nice seeing you, Dennis.
Nice seeing you too, Father.
All right, so is there any other person who may want to make a contribution aside that we would want to draw the curtain down? Okay, so Loadana, I'm extremely grateful for your time this evening. I mean, the experience, the expertise that you brought to us free of charge, which I know arbitrators, they are not expensive there, but they are resourceful. So thank you for such an insight that you've given to us, Stephen. You know, I can always count on you for your time. I'm also grateful for your time.
Anytime, my brother. Anytime, my brother.
We are closing up this year with Lawyer Dinah and Stephen. Next year, we will be restructuring and then having more detailed, more engaging discussions on the areas of law. Lawyer Dinah, we'll come to you again next year for another topic related to ADR. So thank you very much, and it's been a pleasure having you all this year, and hope to see you in January. Thank you.
Thank you.
Thank you.
Please subscribe to our YouTube channel, and then you can go back and enjoy all the topics that we've done so far. Thank you very much.
Thank you. Bye.
Thank you.
Take care, Stephen, everyone.
You answer that.
Thank you.